All right, let me tell you about a case that has been sitting in federal court and demanding our attention. July 2023, an Applebee's restaurant in Kenosha, Wisconsin. Two police departments, Kenosha and Pleasant Prairie, converge on a couple dining with their child. What happens next leads to suspensions and a federal lawsuit alleging Fourth Amendment violations. Now here's what makes this case legally fascinating. We have officers from two different departments, and one of them apparently questions whether they have the right suspects. So the central question becomes this: what does the Constitution actually require when reasonable, articulable suspicion is shaky at best? I'm going to walk through this with you applying the actual legal standards that govern police conduct. Not emotion, not politics, just what the law says and whether these officers followed it. We're going to learn something real about your constitutional rights today. If that sounds valuable to you, hit that subscribe button and let's get into it.
Hey. Are you guys just in an accident?
No.
No?
We've been here the whole time. What's going on?
How long you been here?
We've been here for an hour and 45 minutes.
Yeah? Okay. How long have they been here? Where they? Who's the table that just walked in you guys just called about? Okay.
What are you guys driving?
A quarter 727.
We want to clear you from this, so you can just.
For Genesis Cruise,
No, I'm just asking what you
Senate
drove in.
license, Wisconsin, valid, Illinois
You
non-speaker.
just came up here acting we're doing that. I didn't even know what's going on.
So you don't know which vehicle you came in today?
They were already here when I was here.
You guys got a car in the parking lot?
That's what they're arguing about right now. I know. Which car is yours in the lot?
Okay, so right away I'm noticing something critical here. The officers are engaging in conversation, but listen to how disjointed this exchange is. They're asking about Jamaica and driver's licenses and how long someone's been in town. This is what we call a Terry stop fishing expedition, and it raises immediate red flags under Fourth Amendment jurisprudence. Here's what the law actually requires. Under Terry v. Ohio from 1968, an officer needs reasonable, articulable suspicion that criminal activity is afoot. Not a hunch, not a vague description, specific, articulable facts. And this is where United States v. Socolow becomes instructive. The Supreme Court held that the totality of circumstances must support reasonable suspicion. But what I'm seeing here, officers appear to be gathering information rather than confirming information they already have. That's backwards. What makes this particularly troubling is what we know happened next. A Pleasant Prairie officer reportedly expressed doubt about whether these were even the right people. When you have conflicting assessments between officers on scene and one department proceeds anyway, that's when constitutional violations crystallize. The reasonable suspicion standard isn't just a formality. It exists precisely to prevent what appears to be unfolding here.
Y'all still not saying what's going on there.
Yeah, there was an accident out there, and somebody said that they saw you guys run in with the baby. That's what we're seeing.
They described a female with a top.
So that's why if you guys can tell us what car you came in, we can be done.
That's over with.
They said somebody had red on, carrying a baby.
Yeah, and there's somebody else who's in here with red on too.
But they're not here right now.
Okay, then, so go find them.
So then where's your car that you came in?
That's what you can do too. You can check
Where's the car that you came in?
Somebody. Accident, y'all.
You're not free to go right now. You are detained right now until we can figure it out.
Because I'm going to take my thoughts to the bathroom.
Did you catch that? Am I free to go right now? And the response was, yeah, we're good. That exchange right there is legally dispositive. Let me bring in United States v. Lopez from the Eighth Circuit. That case established a fundamental principle. Once the purpose of a Terry stop has been satisfied or the reasonable suspicion dissipates, the detention must end. There is no discretionary grace period. There is no, let's just wrap a few things up window. What troubles me deeply is what preceded this moment. We know from the federal lawsuit filed in October 2024 that a Pleasant Prairie officer had already expressed doubt about whether English and Boyd were even the correct suspects. When exculpatory information surfaces during a stop and officers acknowledge, we're good, the constitutional clock doesn't just pause, it demands immediate release. The Kenosha Police Department eventually suspended Officers Cordier and Vencis over this incident. That administrative action tells us the department itself recognized something went wrong here. When your own department disciplines you for a detention, that's not ambiguous. What we witnessed was the moment reasonable suspicion collapsed entirely. Everything that happened before that acknowledgement needs to be measured against this admission.
All right, relax.
Touch me. Relax.
You got a baby with you. Relax.
Don't touch me.
Relax,
And then you're gonna be done.
Stop. Back up.
Excuse me. What car do you want? Excuse me. Excuse me.
I'm not. Stop touching me.
You touch me.
Excuse me. Excuse me.
Excuse me. We will be done.
Like, we don't gotta answer no question. I already told y'all we've been here.
You're gonna stay with my.
No, I'm not gonna stay with nobody.
Okay, then put your hands behind your back.
I'm not under arrest. You aren't gonna be the same. Stop. Get the. Oh, you just let me get more. Stop it. Put it more. Let me go. Let me just go. Let me just go. I'm not doing that. Stop it. Stop it. Baby down now. Put your hands behind your back. Put your hands.
Go with him.
Squeeze it up. Stop. Squeezing me. Stop. Are you kidding me? Are y'all kidding me?
Get the off it. Hey, let him go.
Are y'all kidding me? What the resisting?
On the ground now.
Resisting.
Stop, Christ. Stop.
Kenosha police. Stop.
I got it.
What is
What's here? Let go.
Okay. Watch out. What is going on? What is going on? I'm confused. What is going on?
No. Stop the tape right here. Because what I just witnessed crosses every line that Graham v. Connor draws in the sand. Let me be absolutely clear about the legal framework. In Graham v. Connor, the Supreme Court established that force must be objectively reasonable based on the totality of circumstances facing the officer at that moment. The Graham factors ask 3 questions. What was the severity of the crime? Was the suspect an immediate threat? Was the suspect actively resisting or attempting to flee? And here's what makes this footage devastating. By this point, we already know the officers had acknowledged these weren't the right people. So what crime justifies this escalation? There isn't one. What threat did a family dining with their child present? None that any reasonable officer could articulate. The federal lawsuit filed by English and Boyd specifically alleges Fourth Amendment violations, including excessive force. When you draw down on civilians who were never actually suspects to begin with, you have fundamentally inverted every principle of proportionality the Constitution demands. This isn't a close call requiring legal interpretation. This is textbook excessive force applied to people who should have been released minutes earlier. The Kenosha Department's subsequent suspension of these officers confirms what the footage already shows us. This force was constitutionally indefensible.
I'm confused. What is going on?
Yeah, but you're obstructing my investigation. Get out of here. Go over there now.
My workplace, bro.
Back up. Back up. That's fine. You can record. You need to let us do our job.
Bro, I'm not doing nothing. I'll just fucking
Back up.
I'm right here, bro.
Stop moving towards us. Sit over on your butt. On your butt, man.
Oh my God, what is going on?
Sit up. Are you okay?
No, because I'm confused. I'm waiting on my food, my child. What is going on? Y'all putting my hands.
I don't know. I wasn't out here.
No, where's my child?
Are we good now?
This is so up. I'm sitting here waiting on my food.
Stop
That
yelling.
one in custody.
Let's get her out.
All right. Ready? We're going to stand up. Ready?
Just call him. Just call rescue. 7:35. We'll take rescue out here.
We got someone free.
We're going to stand up. Ready?
Call my mom.
No, we're not calling your mom.
You're an adult.
More my child than right this is so right here.
Stop moving forward.
I'm a line right here.
Listen, you can record all you want.
fine.
You step forward one more time, you're going to jail. Do you understand me?
Bro, I'm right here. You see this table? I was standing exactly
you keep
where I stepped
walking
in 2
forward.
seconds ago. Please stop talking to me. I'm trying to see. That's it.
Hold on. Stay there.
Where's my baby? Where's my child? This is so wrong. I can't believe it. Right. It's a bunch of kids. I'm grown as hell.
Yo, back up, else you're gonna get arrested.
I'm done.
Back up.
I did. You just told me I was okay.
Keep moving.
Sir, you just told me I was okay.
Keep moving.
Hey. Tell me when is in the far nose.
Keep going.
Far nose.
Right there.
I
That's
can't
good.
see.
You're gonna stop yelling right now.
You have to stop.
That stands for me.
If you move against me, I'm putting you into the car.
Did you guys hear what happened? No. There was a rollover accident, Highway 50.
Yeah.
Description of 3 adults with the child were running from the scene, likely in this truck.
Is that what you call the bathroom? Was a third person?
I don't know about a third person. So
That's terrible.
was there the 3 people come in?
Arresting someone in the bathroom. And I never knew there was anyone in the bathroom, so I'm like,
No, I'm not going to stop.
Stay back there. Get it for you, but stay back.
No! I'm not
One, I'll get it, Kev.
No!
You got a good grip on her?
Yeah, I got it.
If she acts foolish, you spear her into the car. Just make sure you get clean across that center line. Stop moving.
Stop yelling and give me your mom's number.
Now listen, right now, y'all being detained because it's a car accident. I don't know what's going on, okay? Don't turn into nothing. So if you're going to lie about your name, why do that right now? You feel me? That's where we're at right now.
Get in the car.
Wrong, bro. It's so wrong. I swear to God, bro.
Get the door closed.
All right, you good?
I'm going to go back in there and help.
Yeah.
Bring people in close contact with me.
Hey, I'm calling somebody for this girl that's at Applebee. She just went to jail. Like, we have her baby. What's your name? Shania.
Yeah.
What do you need? I think we're fine here. He's catching his breath.
All right. I'm going to go check with him in the bathroom then.
Good?
Good. Oh, OC exposure.
Thank you. Whoever was spraying over there.
What?
There's all those kids in there.
Can you crack the window?
Yeah.
Like my face burning. Where's my child?
In there.
No, who has my child?
The staff member's in there.
They don't like what's
He's in custody too.
what?
For resisting.
And this is where we have to zoom out and talk about what actually happened after the camera stopped rolling. Because the legal system did eventually weigh in on this case, and the outcome tells you everything you need to know about whether the officer's conduct was justified. The charges against Jamel English and Shania Boyd were dismissed. Let that sink in for a moment. Every charge that resulted from this encounter was thrown out by the court. And this matters enormously because it represents the judicial system itself rejecting the legitimacy of what these officers did. Now let me bring in a legal principle that's critical here. Under Wisconsin law and similar doctrines across the country, there's an important question about resisting arrest. Can you lawfully resist an unlawful arrest? The general rule is no, because courts want compliance in the moment with challenges handled later in court. But here's the thing. When officers lack lawful authority to detain you in the first place, the entire foundation crumbles. The courts looked at this situation and determined that the officers never had the legal basis to escalate this the way they did. The dismissal of charges is the judicial system's way of saying these people should never have been arrested, and nothing they did during this unlawful detention rises to the level of criminal conduct. Think about what that means for police accountability. The Kenosha Police Department suspended officers Cordier and Vinces. The Pleasant Prairie Police Department has implemented additional training on constitutional rights and proper detainment procedures. These aren't cosmetic changes. These are admissions that something went fundamentally wrong. And now there's a federal lawsuit pending in the Eastern District of Wisconsin. English and Boyd are alleging Fourth Amendment violations and seeking accountability not just from the officers, but from the departments and from Applebee's itself for facilitating this encounter. But here's what keeps me up at night about cases like this. What happens to the family that wasn't filming? What happens to the people who don't have the resources to file federal lawsuits? What happens in the hundreds of encounters that look exactly like this one, but never make it onto YouTube? The systemic implications extend far beyond Kenosha. Every time officers violate constitutional rights and face no meaningful consequences, it erodes public trust in ways that take years to rebuild. The Pleasant Prairie Police Department has initiated community outreach programs trying to rebuild that trust. But trust isn't rebuilt through workshops. It's rebuilt through consistent constitutional policing, day after day, encounter after encounter. What we watched over the course of this video was a complete breakdown of Fourth Amendment protections. From the initial stop that lacked reasonable articulable suspicion, to the continued detention after officers admitted these weren't the right people, to the excessive force deployed against innocent civilians dining with their child. Every stage of this encounter violated established legal doctrine. Tennessee versus Garner tells us force must be proportionate. Terry versus Ohio tells us detentions require specific, articulable facts. Graham versus Connor tells us reasonableness is judged from the perspective of a reasonable officer on scene. And by every one of those standards, this encounter fails. The law exists to protect people from exactly this kind of governmental overreach. When it works correctly, constitutional protections prevent innocent families from being brutalized during a meal. When it fails, we get cases like this one. Cases that end up in federal court, with departments scrambling to implement reforms they should have had in place from day one. This is why we watch these videos. Not for entertainment, not for outrage, but because understanding the law empowers you to recognize when your rights are being violated and to demand accountability when they are. Tell me your name and where you're watching from in the comments. I want to know who's out there learning this material with me, because knowledge of your constitutional rights isn't just academic. It's the first line of defense against exactly what we witnessed today.